We would do research if we found that they had been historically located in our right-of-way. They moved their poles at their cost. If we were able to document that they had their own easement for whatever part of the pole, we reimbursed them for the cost of moving. This typically works fine with our EMCs, our MEAGs. We have had difficulty with Georgia Power. Historically, we have not had difficulty with Georgia Power, but evidently starting in the 2007-2008 timeframe, it has become increasingly difficult to negotiate the movement of these poles during a road project. Typically what would happen with Georgia Power is we would ask them to bring to us whatever documentation they had of prior rights. They would bring it to us, we would evaluate it, look at our own research, and go back to them and negotiate the cost of the pole relocation. This sort of flip-flopped in 2007, 2008, and now what they ask us to do is to bring to them dedicated deeds showing that we have the right-of-way before they will begin to discuss the pole relocation. And the general position they take now is, unless we can document otherwise, we are responsible for paying for the relocation of these poles and wires during a road widening project. And to give you an idea of the amount, well, let me preface this by saying, to keep the projects moving, because we had come to an impasse, to keep the projects moving, Georgia Power drafted a utility relocation agreement with a cap amount, a not to exceed amount. And it provided within the terms of the agreement a mechanism for handling what we call the disputed amount. So to give you an example, I have numbers right here. On Lower Roswell Road, which is in East Cobb County, Georgia Power came in and they said that they were entitled to about $550,000. We did our research and determined that they were only entitled to about $75,000. So with this utility relocation agreement, we pay them the $75,000, and this other roughly $475,000 is disputed. And we handle that in negotiation, mediation, ultimately litigation if we need it. This has become the context for most of our road projects now. On Floyd Road, they came in asking for $1 million. We determined that we owed them $300,000, so we've got $700,000 floating around out here. So right now we have over $1 million that they claim they're entitled to, because they say we can't substantiate ownership of the right-of-way with a recorded deed. But as you all know, a lot of times historically you have old franchise agreements or deeds, or you have obtained prescriptive rights to roads, and it makes it very difficult to document right-of-way that you've maintained, particularly from the center line to the edge of what you claim the right-of-way to be. Now, the bigger issue, because we do have these agreements which allow the projects to move forward, the sort of subset issue is what we call pole attachment. And along with the relocation, prior rights issue, what Georgia Power has determined is that they will no longer allow us to attach our infrastructure to their poles that are in our right-of-way without a license agreement. So that means lines for school flashers, traffic cameras, various traffic infrastructure lines. They will not allow us to attach to the poles without a license agreement. They have, and to get the license agreement, they have imposed a number of onerous requirements. For instance, they want periodic payments, they want interest if there are late payments, they want us to carry certain sorts of insurance in order to be able to attach to these poles. And again, these are for poles in our right-of-way. We're not talking about poles and their easements outside county right-of-way. They have negotiated with the state a license agreement for the state to use. And so the state has a license agreement with Georgia Power for their poles that are in state right-of-way. They will not allow us to use that agreement, and that agreement is considerably less onerous than the one that they want us as a county to use. If we could use the state agreement, we'd be happy to do so. But they tell us we're different from the state, there are different political considerations, so they're going to have a different agreement for counties and a different agreement for the state. So what we've done is we have asked Roy Barnes to assist us in negotiating with Georgia Power. We are moving forward on some projects, but we have one project that has been completely shut down for 5 months because of this pole attachment issue. I just wanted to update you all. We were trying to get information to find out if anybody else has had difficulty with Georgia Power, either on the prior rights or the pole attachment issue, because we didn't know whether it would be more useful to band together as a group in negotiating a position with Georgia Power, or whether we need to be a test case moving forward.
When you say we, who are you talking
Cobb County Board of Commissioners.
about? Why wouldn't it be more advantageous if everybody joined together as a group, much like Blue Cross Blue Shield with ACCG?
Well, I think it might be beneficial if Roy Barnes could speak on behalf of counties, not just Cobb County, but counties in general, in negotiating a position with Georgia Power. I think it would be beneficial.
What do you have to do to get that, to bring that to fruition?
Well, we need to find out who's interested.
Wouldn't Cobb County send out a questionnaire to the county managers or to the Board of Commissioners?
We could do that. I could work with Mr. Grubiak and find out who's interested and give you the information that we have. It would certainly be more cost efficient, I think, in pursuing to have a group.
That would require each of the boards to approve that cost.
Yes.
Whatever that would be, which would take a considerable amount of time with 159 counties.
I agree.
We just had that happen, that's the reason I asked that.
Well, what I can do, I'm certainly happy to do this, is I can provide my contact information to Mr. Grubiak, and he can send it out, because our feeling is if we could even get a few counties who are interested or who are having problems with Georgia Power to come on board. And really, what we're thinking, we have discovered some historical documents in our in the clerk's real property records, which we feel gives us a decent position in going back to Georgia Power. We don't know whether Georgia Power has the documents or not, but it probably takes some research on your part to figure out historically with a particular road that you're having issues on, what your position is, what your rights are, what your prior rights are. But to the extent that we could have these test cases, these test road cases in different counties, and approach together Georgia Power and maybe carve out a position that's beneficial to counties in general, I think it would be easier down the road, because we have some big projects coming up where we have a real concern that they're dead in the water before we get started because of this pole attachment issue.